Right first time. A practical guide for public authorities in Scotland. Good decision-making is an essential part of good government. It is fundamental to the rule of law ideal that official decisions are fair, efficient, accessible and not arbitrary, and that they comply with the law. Right first time was designed and introduced in 2010 to assist any public decision-maker comply with these high standards. Countless decisions are made on a daily basis by public authorities in Scotland which impact on members of the public. Whether those decisions relate to the determination of a planning application, an application for the placement of a child in a particular school, or the decision to make or refuse a grant, they must all be lawful, fair and reasonable. Making the best possible decisions first time round will increase public confidence in the quality of decision-making within Scotland's public authorities. A decision which has been properly made will also be better equipped to withstand scrutiny and challenge, whether by internal review, or by external bodies such as the Scottish Public Services Ombudsman, or the courts. The law surrounding decision-making can seem very complex. Right first time takes you through the process step by step. However, it is intended to complement, rather than act as a substitute for taking legal advice, particularly since the law can change quickly. Right first time was prepared by a team of solicitors, within the Scottish Government Legal Directorate, and the Lord Advocate's own Legal Secretariat, and is the first guide of its type aimed at decision-making by public authorities in Scotland. If you are responsible for making, or advising on decisions, the legal considerations you have to take into account may sometimes seem daunting, even bewildering. What should you be thinking about, or doing, and when? Right first time has 18 questions that you must legally consider over 4 simple steps. These are: Step 1, prepare, getting ready to decide, contains 10 questions that you must legally consider. 1. Where does the power to make this decision come from, and what are its legal limits? 2. For what purposes can the power be exercised? 3. What factors should I consider when making the decision? 4. Is there a policy on the exercise of the power? 5. Does anyone have a legitimate expectation as to how the power will be exercised? 6. Can I make this decision or does someone else need to make it? 7. Have devolution and the Scotland Act affected the power? 8. Am I complying with human rights and European law? 9. How has equal opportunities legislation affected the power? 10. Am I handling data in line with data protection, or freedom of information obligations? Step 2. Investigate, investigation/evidence gathering process. 11. Does the power have to be exercised in a particular way? For example, does legislation impose procedural conditions or requirements on its use? 12. Have I consulted properly? 13. Will I be acting with procedural fairness towards the persons who will be affected? 14. Could I be, or appear to be, biased? Step 3. Decide, taking the decision. 15. Have I taken necessary considerations into account, and is my decision reasonable? 16. Does the decision need to be, and is it proportionate? 17. Are there decisions where the court is less likely to intervene? Step 4. Notify, notifying others of the decision. 18. To what extent should I give reasons for the decision? What does the legal jargon mean? The court usually means the Court of Session in Edinburgh by judicial review. Other courts like the Sheriff Court will also enforce the rules described in this guide, for example in specific areas like licensing appeals, or if human rights and European law issues arise. European law. Previously the law which applies as a result of membership of the European Union, mainly the law of the European Community. See Question 8 and Annex 2. European law considerations. In 2016 the people of Scotland voted decisively to remain within the European Union, even although England and Wales largely voted to leave the EU. The Scottish Government and large majority of Scots continued to believe that staying in the EU is the best option for Scotland, and this will lead to a new referendum on Scottish independence and rejoining the European Union as an independent member state. Therefore we have kept the legal obligations of EU law in this presentation. Human rights. The rights protected by the European Convention on Human Rights, also known as the Convention, not directly related to European law. Also known as ECHR or Convention rights. See Annex 1. Judicial review. The procedure the Court of Session in Edinburgh uses to supervise decisions of public, as well as other, authorities in Scotland. See Annex 3, a short guide to judicial review proceedings in Scotland. The Scotland Act. The Scotland Act 1998 is the piece of legislation that established the Scottish Parliament and the Scottish Government, although referred to in the Act as the Scottish Executive, and gives them their powers. Statute, legislation. Acts of the Westminster or Scottish Parliaments. Also covers regulations, orders or rules made under powers given to ministers and others by acts, often published as statutory instruments, SIs, or devolved Scottish statutory instruments, SSIs. Ultra vires. Latin for out with the powers of an authority. See Question 1. Part 1, Prepare. Question 1. Where does the power to make this decision come from, and what are its legal limits? A decision-maker may appear to have unlimited powers. A statutory provision conferring a power may say the Scottish ministers shall grant or refuse the application without qualification. But however unlimited the power appears to be, there may be legal limits. To ensure that a decision is lawful and fair, and is not overturned on review by the court or challenged by any other authority, the starting point is to understand the nature of the power. Some limitations may be express, the purposes for which a particular power was given, or the criteria to be applied in exercising it, may actually be set out in the legislation. Other limits will be implied by the statutory scheme that gives the powers. Other limits may be derived from the principles of administrative law. These include legality, acting within the scope of any powers and for a proper purpose. Procedural fairness, for example, to give an individual an opportunity to be heard. Reasonableness or rationality, following a proper reasoning process and so coming to a reasonable conclusion. Compatibility with human rights and European law. To act lawfully, a decision-maker must have the legal power to do what he or she intends to do. If not, that person will be acting ultra vires or outside his or her powers. Where the power does exist, it will usually be found in legislation. It will be necessary to study the legislation to learn the limits and purposes of the power and to consult accompanying documents such as explanatory notes for assistance. Where doubt remains, you should consult your lawyer. Sometimes the government and public authorities will derive their power to act from a contract, or, in the case of government, from ministers' powers at common law, for example power to employ staff. In addition, there are some powers which are considered part of the royal prerogative of the Crown because ministers act on behalf of Her Majesty the Queen. If the power is contained in legislation, you will need to look at its words to work out what the decision-maker can and cannot do. Usually, words in a statute are given their plain English meaning. Where the words might give rise to a different interpretation, the court will try to determine the intention of the Parliament that made the legislation. Either way, you will need to understand the general purpose of the statute, as well as the particular provision. It can sometimes be helpful to consider the explanatory notes to an act or the executive note for subordinate legislation, and the record of any proceedings in the Scottish or UK Parliament. The court will also read legislation so as to comply with human rights, European law and, in the case of legislation made by the Scottish Parliament, the Scotland Act. A power, or a duty. Sometimes, even though the words in the legislation indicate that there is discretion as to whether or not to act, for example that the public authority may do something, there are cases where it must be interpreted as imposing a duty to act. For example, a public authority with the power to grant licenses may be obliged to do so where an applicant fulfills all the prescribed requirements. In order to determine what a law means when it says may, or for that matter shall, you have to look at the law in question and its purposes as a whole. If in doubt, contact your lawyer. There may be a power available to a public authority, but it may have a discretion about whether or how it is to be exercised. Case law, RMV Scottish Ministers, 2008. A patient challenged the Scottish ministers' failure to make regulations under the Mental Health, Care and Treatment, Scotland Act 2003 introducing a formal mechanism to allow restricted patients detained in medium and low security hospitals to challenge their conditions of security. Regulations introducing such a mechanism for those detained in high security hospitals had already been introduced. Having examined the background to the Act, its passage through Parliament and guidance issued by the Scottish Health Department following its coming into force, the court held that it was clear that the provision allowing regulations to be made was intended to deal with a problem which may arise at some point in the future. Parliament had not intended to impose a time-limited duty on the Scottish ministers to make the regulations. Who can review decisions? For the purposes of this guide, reference is made in general to the court reviewing decisions. However, it should be borne in mind that decisions are often reviewed internally as well as by administrative tribunals. A decision may also be reviewed by the Scottish Public Services Ombudsman. Where a person is unhappy with the service they have received, which could include a decision or series of decisions, from a public body falling under the remit of the Scottish Public Services Ombudsman, they may make a complaint and have it investigated. C. Also in particular. Question 6. Can I make this decision, or does someone else need to make it? Question 7. Have devolution and the Scotland Act affected the power? Question 8. Am I complying with human rights and European law? Question 2. For what purposes can the power be exercised? As well as having the power to act, a public authority must use its power for a lawful purpose. Its action will be ultra-vires and an abuse of power if it uses the power to achieve a purpose for which the power was not intended. Case law, Jerry Cottle's Circus Limited v City of Edinburgh 1990. A circus company applied to a local authority for a temporary public entertainment license. The license was refused. The local authority stated that although they had not applied a blanket policy, the local authority had a policy which did not permit circuses featuring performing animals based on the fact that the whole concept of animals performing in circuses was wrong. The court found that the powers the local authority had been given by Parliament related to the registration of those wishing to provide public entertainment. This did not permit the local authority to prohibit types of performance of which it simply disapproved. Legislation may expressly set out the purposes for which a power may be exercised, or they may be implied from its objectives. The court has accepted that a public authority may undertake tasks conducive to or reasonably incidental to a defined purpose. If, for example, a decision-maker has the power to hold a public hearing to assist in making a decision, related powers to hire accommodation, pay for, IT etc. will be treated as being reasonably incidental to that purpose. C. Also in particular. Question 1. Where does the power to make this decision come from, and what are its legal limits? Question 10. Am I handling data in line with data protection, or freedom of information obligations? Question 18. To what extent should I give reasons for the decision? Question 3. What factors should I consider when making the decision? To make a decision which is lawful, two main principles should be followed. You should not base your decision on irrelevant factors or considerations, and if there are factors or considerations which you have a duty to base your decision on, then you must do so. There are certain rules which will help you to decide what factors you have a duty to consider, what factors are relevant, and those which are irrelevant. If you are using powers given to the public authority by a statute, it might set out the factors on which you should base your decision. Some statutes set out factors which you have to pay particular attention to. So, whilst the statute doesn't set out every factor which you can consider, it does mean that you have to follow the factors that are listed. If the statute doesn't set out factors to be considered, then it helps to look at what the statute is trying to achieve, its purpose, and from that decide what factors are relevant to the decision you are to make. If your decision is challenged, the court will want to know the factors that you considered. For example, the media's reaction to a decision is unlikely to be relevant to the purpose of the statute, and the court would be likely to decide that this was an irrelevant factor on which to base a decision. Case law Bantop Limited v Glasgow District Licensing Board 1989. An application for a regular extension to permitted hours was made to a licensing board. In considering whether or not to grant the application, the licensing board was, in terms of the statutory provisions, to have regard to the social circumstances of the locality or to the activities taking place in the locality. The licensing board took into consideration that the local environmental health department had reported 1 week earlier that the premises were in an unsatisfactory condition. The court decided that, in terms of the statutory scheme, this was not a relevant factor on which to base the decision. To take into account all relevant considerations required to come to a decision, you need to make sure that you have accurate and up-to-date information. Where you don't have the information that you need to make the decision, you have to make sure that you can get it from those who have it. You should consult, see question 12 of this legal guide, and follow any guidance or points of reference in place within your public authority which relate to the way the decision has to be made. Where representations have been made regarding the decision, you should take account of them where appropriate. Case law. Aberdeenshire Council v. the Scottish Ministers, 2008. In a planning appeal against the refusal of outline planning permission for a residential development on agricultural land, the court found that the reporter, in considering the application, had failed to address the evidence on housing land supply and had also misconstrued the significance of supplementary planning guidance. He had not undertaken sufficient analysis of the evidence and did not take account of material elements. Rather, he applied his own personal view of the application and failed to identify any material consideration which would properly allow for departure from the development plan. He had also failed to properly specify what was meant when he gave as one of the reasons for refusal that the developer's proposal did not satisfy the definition of affordable housing. The decision was struck down. It is important to remember that it is the factors which are used in making the decision that are important here, and that you must be able to demonstrate that you have properly considered them. In addition to looking to your powers, you should also consider whether your decision could affect an individual's human rights. If so, then evidence that you have taken such considerations into account could assist you in responding to any challenge to the decision. Whatever factors you decide are relevant, you need to be sure that the facts on which you base your decision are accurate and up to date. You should also consider whether the factors that influenced your decision, and the decision-making process itself, need to be recorded. In determining what should be recorded, it is worth bearing in mind the rights to access information created by the Data Protection Act 1998 and the Freedom of Information, Scotland, Act 2002. See, also in particular. Question 1. Where does the power to make this decision come from and what are its legal limits? Question 10. Am I handling data in line with data protection or freedom of information obligations? Question 18. To what extent should I give reasons for the decision? Relevant considerations might also be policies, see question 4. Legitimate expectations, see question 5. Representations received, see questions 11 to 13. Question 4. Is there a policy on the exercise of the power? Where a statute has conferred a discretionary power on ministers or another public authority to issue something such as a license, they will potentially have to deal with hundreds or thousands of cases. The statute may spell out the criteria for the grant of the license in general terms, but the decision-maker may still be left with a wide discretion. To ensure consistency and promote administrative efficiency, the decision-making authority will probably develop a standard way of dealing with such cases. They will try to apply the same criteria, attaching the same weight in each case. They will develop a policy for dealing with cases. However, where statute confers a discretion on an individual, he or she must not surrender that discretion to another person, to a set of rules, or to a policy. The decision-maker must keep an open mind and consider each case on its own merits, otherwise there is a failure to exercise discretion properly. The authority must not close its ears to particular arguments. The court has held that it is lawful for decision-makers to have a policy as to the way in which discretion should be exercised. Indeed, to achieve consistency in decision-making it may be essential that there is a policy. But the court has also held that the decision-maker must nevertheless direct his or her mind to the facts of the particular case and be prepared to make exceptions. This is particularly important in cases involving human rights and considerations of equality. Equally, where a decision-maker does have a policy, he or she should not depart from it without giving an explanation or should ensure that a change in policy is compliant with the law. Case law, Abdi and others v. Secretary of State for the Home Department, 2008. The court criticized the Home Secretary for departing from a published policy relating to foreign national prisoners where there had been a decision to deport. The policy was that there was a rebuttable presumption that the prisoner would be released pending deportation. The policy was changed so that the presumption was that the prisoner would not be released, but that change in policy had not been published and so was insufficiently open and accessible. The decision-maker must keep an open mind and consider the facts of every case, and make it clear that this has been done in the terms of the decision. This approach is also more likely to be proportionate in human rights terms because it allows a proper assessment of whether any interference with human rights is necessary on the facts of the particular case. See, also in particular. Question 5. Does anyone have a legitimate expectation as to how the power will be exercised? Question 9. How has equal opportunities legislation affected the power? Question 13. Will I be acting with procedural fairness towards the persons who will be affected? Question 5. Does anyone have a legitimate expectation as to how the power will be exercised? An authority must act within its powers, must not close off, or fetter, the exercise of its discretion, and may exercise that discretion in accordance with a policy, provided it is operated consistently but not too rigidly. Sometimes a tension arises between these principles in practice. Suppose an authority operates a policy or procedure consistently, but a change of circumstances, or a review of where the public interest lies, means that there is a need to modify the policy or procedure. Or suppose the decision-maker misunderstands the extent of his or her legal powers and offers to an applicant a benefit, for example, planning permission, for which the applicant is not qualified under statute. In this kind of situation, someone affected by the decision can have a legitimate expectation that because the policy or procedure has been operated in such a way in the past, that this will continue in the future. Equally, if the authority has promised someone in particular a benefit, it may, depending on the circumstances, be unfair to break that promise, even if there are public interest grounds for breaking it. The key to resolving these tensions is to strike a balance between the public interest, for example in changing the policy, and the private interest in maintaining it. Where a legitimate expectation has arisen, a public authority can still frustrate that expectation if any overriding public interest requires it. Whether a legitimate expectation has arisen, and whether it can be overridden, will depend upon a number of factors, such as were the words or conduct, the promise or representation, which gave rise to the expectation clear and unequivocal. Did the person promising the benefit have the legal power to grant it, or was it ultra vires? Who made the promise and how many people stood to benefit by it? Did the persons to whom the promise was made take action in reliance upon it which has placed them in a worse position than they would have been in if they had not taken that action? These are some of the factors which the court will take into account in deciding whether a legitimate expectation has arisen and whether it is fair, or would be an abuse of power, to allow the public interest to override it. If the decision-maker had no legal power to make the promise/representation, then a claim of legitimate expectation is unlikely to succeed, though there could be exceptions to this where human rights are in play. Where it is intended to change a policy or a procedure, for example, to change a practice of accepting late applications, practical steps should be taken to address potential claims of legitimate expectation that the policy or procedure would continue, by clear publicity, by careful explanation why the change is necessary, and possibly by consultation with regard to the timing of any change or to the new procedure to be adopted. Case law, McPhee v. North Lanarkshire Council 1998. Mrs. M agreed to remove herself voluntarily from a pitch on a travelling person's site on condition that she would be offered a pitch on the site following completion of modernisation works. An unconditional assurance was given and confirmed in writing. When the site was reopened, she was not given a pitch. Mrs. M sought review of the decision on the grounds that she had a legitimate expectation that her application would be granted. The court had to consider whether there were factors which would permit the authority to depart from the assurance that had been given. In this case, Mrs. M had not been honest in her application form, and the court held that this was a factor which would justify departure. See, also in particular. Question 4. Is there a policy on the exercise of the power? Question 13. Will I be acting with procedural fairness towards the persons who will be affected? Question 6. Can I make this decision, or does someone else need to make it? The Kaltona Principle. The general rule is that where legislation confers a power on a specified individual or body, the power must be exercised by that individual or body and must not be given away to another person or body. However, there are many exceptions to this rule. In particular, the court accepts that government ministers cannot possibly make personally every decision which is made in their name, and that officials may act on their behalf. This is known as the Kaltona Principle after the leading case Kaltona Limited v. Commissioners of Works, 1943. The theory is that, legally and constitutionally, the acts of officials are the acts of their ministers provided the official is acting with the express or implied authority of the minister. The principle does not, however, apply in local government. Where the Kaltona Principle applies, a decision may still only be taken on a minister's behalf by an official of appropriate seniority and experience. And there will always be some cases where the special importance of the decision, or its consequences, mean that the minister must make the decision personally. Sometimes specific statutory provisions require that the minister make the decision personally. If the power can be delegated, you need to check whether there are limitations on the seniority of officials who can exercise it on the minister's behalf. Sometimes, before you can make your decision, you will need information or policy input from another public authority. If so, it is important to remember that the decision is one for you as the decision maker, having regard to all the circumstances, including the advice or recommendation of that other authority. You should not merely rubber stamp the advice or recommendation which you receive from elsewhere. Rule 94, The Prisons and Young Offenders Institutions, Scotland, Rules 2006. In terms of the Scottish prison rules, a governor has the power to remove a prisoner from association for particular reasons, including maintaining the good order of the prison, for a period of up to 72 hours. The Scottish ministers may authorise an extension of that removal on the application of the governor. On the basis of the Kaltona Doctrine, the decision on an extension may be taken by a duly authorised civil servant of a senior grade on the minister's behalf. See also in particular. Question 7. Have devolution and the Scotland Act affected the power? Question 14. Could I be, or appear to be, biased? Question 7. Have devolution and the Scotland Act affected the power? Have devolution and the Scotland Act affected the power? At present, the Scottish Parliament has powers to make laws in devolved areas, but in reserved areas those powers remain with Westminster. The functions of many public authorities in Scotland were relatively unaffected by devolution, though they may be affected by subsequent acts of the UK or Scottish Parliament. The powers of the Scottish Government, and wider Scottish administration, on the other hand, are closely aligned to the functions of the Scottish Parliament. Whether a law is devolved or reserved depends on its subject matter, its purpose and, among other things, its effect in all the circumstances. The UK and Scottish governments have legal powers only over the matters that are within the range of subjects they control. Ministers and civil servants in the Scottish government, and in the UK government, therefore need to ensure that any decisions that they make have a lawful basis given the terms of the Scotland Act. There are, however, a range of mechanisms in the Scotland Act that allow the boundaries of devolution to be altered. Since devolution, a range of alterations have been made. An Act of the Scottish Parliament or the purported exercise of powers by the Scottish ministers can be struck down by the court, if it has an effect beyond that permitted by the Scotland Act on reserved matters, or if it is incompatible with human rights or European law. However, as a general rule, you can assume that the current legislation is within the competence of the Scottish Parliament and proceed to make your decision on that basis. See also in particular. Question 1. Where does the power to make this decision come from and what are its legal limits? Question 8. Am I complying with human rights and European law? Question 8. Am I complying with human rights and European law? Human rights considerations permeate many areas of the work of public authorities in Scotland. The Human Rights Act 1998 requires public bodies to act compatibly with a wide range of the rights set out in the European Convention on Human Rights. For public authorities other than the Scottish Government, the only exception to this is where a duty under primary legislation made at Westminster means that you cannot do otherwise, such as enshrined in Section 6(2) of the Human Rights Act 1998. The key human rights are in Annex 1, the main convention rights. The Scotland Act also obliges the Scottish ministers and the Scottish Parliament to act compatibly with both human rights and European law. As the UK is part of the European Union, European law overrides Scots law. In fields governed by European law, for example agriculture and parts of environmental law, broad principles of European law apply. Much significant European legislation applies directly in Scotland and can be relied upon against public authorities in Scotland. Key European law issues are summarised in Annex 2, EU law considerations. This will inevitably change on exit day from the European Union, and the Scottish Government's objective is to convert devolved direct EU legislation into Scots law on and after exit day under the Charter of Fundamental Rights. Section 5(1) provides that the general principles of EU law and the Charter of Fundamental Rights are part of Scots law on and after exit day so far as they a. have effect in EU law immediately before exit day, and b. relate to anything to which Section 2, 3 or 4 applies. Case law, Kennedy and another v. Lord Advocate and Scottish Ministers, 2008. Mrs. B's husband died after receiving contaminated blood. She asked the Lord Advocate to hold a Fatal Accident Inquiry, FAI, into the death in terms of the Fatal Accidents and Sudden Deaths Act 1976. The holding of INFI is at the discretion of the Lord Advocate. The Lord Advocate declined to hold such an inquiry. Mrs. B complained that this refusal was a breach of the investigative obligation present in Article 2 of the Convention, the right to life. The court agreed and held that the decision not to hold INFI should be reduced. The investigations that has been carried out were insufficiently wide in scope and there had been no practical or effective investigations into the death. In this case example, the decision made by the Lord Advocate was within the terms of the statute, but the particular exercise of the power was incompatible with a human right, and was therefore annulled. The Human Rights Act also adds an important dimension to interpreting legislation. So far as it is possible to do so, legislation must be given effect to in a way which is compatible with human rights. Case law, Smith v. Scott, 2007. A prisoner challenged the blanket ban on voting, which applied to convicted prisoners serving custodial sentences, imposed by Section 3(1) of the Representation of the People Act 1983, as amended. The claim was made to the right to free elections in Protocol 3 to the Convention. The court considered whether it was possible to read the legislation in such a way as to make it human rights compliant, but found that there was no way to do so because it could not choose among the multiple policy alternatives. To do so would mean it was effectively legislating on its own account. The court therefore declared the legislation incompatible with human rights. See also in particular. Question 7. Have devolution and the Scotland Act affected the power? Question 14. Could I be, or appear to be, biased? Question 16. Does the decision need to be, and is it, proportionate? Question 9. How has equal opportunities legislation affected the power? There are a number of pieces of legislation which make it unlawful to act in a particular way or reach a particular decision where it would be discriminatory. The Human Rights Act 1998 and European law prohibit discrimination in certain circumstances. The Equality Act 2010, and regulations under it, contain prohibitions on discrimination on grounds of sex, race, disability, religion or belief, or sexual orientation in the exercise of most public functions. The Scotland Act reserves the subject matter of equal opportunities to the UK Parliament, with the exception of the encouragement of equal opportunities by, and the imposition of duties on, the Scottish Government and Scottish public authorities to ensure that their functions are carried out with due regard to the need to meet equal opportunities requirements. A decision may be unlawful, therefore, if it fails to have due regard to the need to eliminate unlawful discrimination and promote equality of opportunity. Specific provisions of equalities legislation also impose duties on public authorities to evidence that they have shown due regard to certain matters under the Equality Act 2010. The public sector equality duties for race, gender and disability require public authorities to undertake equality impact assessments to ensure that the implications of decision-making, both positive and negative, for different groups in society have been considered. Decisions must therefore be taken with due regard for the need to eliminate unlawful discrimination and harassment, eliminate unlawful racial discrimination, eliminate discrimination that is unlawful and harassment of disabled persons related to their disabilities, promote equality of opportunity between men and women, promote equality of opportunity and good relations between persons of different racial groups, promote equality of opportunity between disabled persons and other persons, take steps to take account of disabled persons' disabilities, even where that involves treating disabled persons more favorably than other persons. Promote positive attitudes towards disabled persons. Encourage participation by disabled persons in public life. Failure to do so may lead to a decision being struck down. Case Law, RCV The Secretary of State for Justice, 2008. In 2007 the Secretary of State made amendments to the rules in accordance with which, secure training centres, STCs, in England and Wales had to be run. Secure training centres accommodate young people, trainees, who have either been sentenced to custody or who have been remanded in custody. The amendments permitted officers in secure training centres to physically restrain trainees if it was necessary for the purposes of ensuring good order and discipline. The amendments to the rules were challenged, not because they were discriminatory, but because, amongst other things, no racial equality impact assessment was carried out before the Secretary of State had made them. The courts considered that the amendments to the rules were plainly a change in policy and a matter that might raise issues about racial equality, in view of the significant numbers of black and ethnic minority trainees accommodated in secure training centers. The Court of Appeal decided that the rule of law and the proper administration of race relations law required the amendment rules to be quashed. As can be seen from the case example, the duty applies even in cases where you might think you are not making a significant change or where you think your decision will affect everyone equally. Other cases where challenges have been brought arguing that the duty was not carried out, or not carried out properly, have included decisions on planning control, an ex gratia compensation scheme and the funding of voluntary organizations. What does a duty to have due regard to these needs require you to do when making a decision? There are no reported cases in the Scottish courts, but the Court of Appeal in England and Wales in the case of R. Baker and others, v. Secretary of State and London Borough of Bromley, 2008, has said that due regard means the regard that is appropriate in all the circumstances. These include on the one hand the importance of the areas of life of the members of the disadvantaged group that are affected by the inequality of opportunity and the extent of the inequality, and on the other hand, such countervailing factors as are relevant to the function which the decision-maker is performing. The duty, however, is not a duty to achieve the elimination of discrimination or the promotion of equality of opportunity. It is only a duty to have regard to the need to achieve these goals. There are relevant materials that will assist you in complying with these duties. The Equality and Human Rights Commission have published codes of practice, such as the Gender Equality Duty Code of Practice, Scotland, which still have effect, on the performance of these duties and good practice examples from the implementation of the duties by public bodies. The Scottish Government has published schemes which show how it intends to fulfil these obligations, such as the Gender Equality, Race Equality and the Disability Equality Scheme. An Equal Opportunities Impact Assessment Toolkit and guidance are available through the Scottish Government intranet to all Scottish Government staff to help ensure these duties are met. Other public authorities will have their own schemes and guidance. NHS 24 Equal Pay Review. The gender equality duty requires that listed public bodies consider the need to have objectives to address the causes of any gender pay gap. In late 2007 and early 2008, NHS 24 carried out an equal pay review to ensure their compliance with the element of the gender equality duty that requires public bodies to publish arrangements for delivering equal pay and then to report on progress. Although the NHS has a national pay review programme, Agenda for Change, NHS 24's first Equality and Diversity Annual Report, Delivering Equality, Embracing Diversity, published in September 2007, highlighted the fact that there was a need to gather further information on a number of related issues. These included wage levels, actual earnings, the implication of part-time working, gender segregation, shift work and continuous service, among others. An equal pay review was identified as the most appropriate tool to complement work on, and add value to, meeting specific employment duties as well as providing an evidence base for the delivery of equal pay. The Equal Pay Review is available on the NHS 24 website. The review found an overall pay differential between women and men, and within particular grades, enabling a further exploration as to the underlying reasons. NHS 24 has now committed to undertaking an annual update of the review to help address any structural factors which may cause pay differentials between women and men. Glasgow City Council Equal Pay Case. The local authority announced in January 2018 that it planned to reach a negotiated settlement on thousands of equal pay claims arising from a pay and conditions scheme introduced more than a decade ago. Campaigners said the scheme led to workers in female-dominated roles such as catering or cleaning receiving up to £3 an hour less than those in male-dominated areas such as refuse collection. Following two judgments against the Glasgow City Council in the Court of Session, the local authority administration said it had grasped the nettle and planned to settle about 12,000 claims. The Scottish Accounts Commission stated this year that dealing with these claims has been the most significant development, with more than 98% of cases settled at a total cost of £505 million. On the 11th of June 2020, the regulator stated that they expect councils to maintain their focus on unresolved cases as the 32 local authorities in Scotland have spent £1.3 billion settling cases of pay inequality between male and female staff. In 2018-19, councils in Scotland reported that their gender pay gap between men and women was 4%, 0.5% lower than in 2015-16. The 2017 audit found that between 2004 and 2016, around 70,000 equal pay claims were lodged against councils. At that point, councils had spent about £750 million covering the costs of compensation agreements and legal fees. Question 10. Am I handling data in line with data protection, or freedom of information obligations? Data protection. Information about individuals held by public authorities is governed by the Data Protection Act 1998, the DPA, as is such information held by private bodies. The Data Protection Act is a UK statute which gives effect to a European directive. If the information is biographical, and is capable of being used on its own or in conjunction with other information to identify a person, it is probably covered by the Data Protection Act. Where it applies, the DPA restricts the use you can make of the information, and allows the individual rights to get that information. There are a wide range of exemptions which can apply, for example national security, and where disclosure is required by law. However, you should proceed on the basis that any information that you receive or generate about an individual could end up being seen by that individual. You should ensure that all personal information is accurate, up to date, kept for no longer than necessary, and stored safely. More information is available on the Information Commissioner's Office website for the general requirements of the Data Protection Act. Issues often arise about sharing information obtained for one public purpose for another, usually known as data sharing, either between public authorities or within a single public authority. Information should only be accessed and used in decision-making when there is a proper basis for you to have sight of the information. There is detailed Scottish public sector guidance available from the Scottish Government's website below. Freedom of information. Under the Freedom of Information, Scotland, Act 2002, members of the public are given rights to get information from most Scottish public authorities merely because it is held by the authority. They do not require to give reasons for their request. You should bear in mind when making a decision, that the information you have available to you and the material that you generate in the course of the decision-making process may subsequently require to be released, either proactively or in response to a Freedom of Information request. There are a wide range of exemptions, though many are subject to a public interest test. Where that test appears to apply, it has to be considered in relation to each piece of information. You should remember that information should be released unless there is a good reason in terms of the exemption not to release it. Your decision can be reviewed by the Scottish Information Commissioner. Part 2. Investigate. Question 11. Does the power to make the decision have to be exercised in a particular way? For example, does legislation impose procedural conditions or requirements on its use? Correct procedure, or due process, is vitally important, because there are some tried and tested procedural mechanisms which are likely to secure a just outcome and demonstrate the rule of law. The so-called rules of natural justice are rules of procedure. What amounts to a fair process may vary depending on the circumstances. As a general rule, however, a person likely to be affected by a decision should be given adequate notice to allow them to make representations. This may mean that they have a right to an oral hearing, or it may just allow them an opportunity to make written submissions. If there is available evidence, then there must be an opportunity for all parties to consider and make representations. In determining whether there has been a fair hearing, the court will consider whether there has been equality of treatment. Case law. Yea, Glasgow, Limited v City of Glasgow District Licensing Board 1994. In a case involving an application by the holders of an entertainment license for an extension of permitted hours, the Chief Constable objected on the basis of a number of incidents which had taken place in the immediate vicinity of the premises. The licensing board accepted that the objections were relevant to their consideration and of a serious nature, whether taken individually or together. It refused the application on the basis that the extension was likely to cause a public nuisance or be a threat to public order or safety. The applicants argued that there should have been an opportunity to lead evidence before the licensing board, but the court felt it was sufficient to ensure a fair process that the license holder had a fair opportunity to correct or contradict the information provided by the Chief Constable. Each party had, and took, the opportunity to make submissions about what was alleged. Legislation can also impose specific procedural conditions or requirements which must be satisfied before a power can be exercised. For example, legislation might stipulate that the Scottish ministers or another public authority must consult with particular persons, publish a decision in draft, make due inquiry, consider any objections before making a decision. These procedural requirements are important, and failure to comply with them may make a decision invalid. The decision-maker will need to fulfill them, and be able to show that they have been fulfilled, in spirit, as well as literally. Occasionally, if the requirement is technical, or breach of the required procedure does not defeat the purpose of the statute or damage the public, a failure to satisfy it will not necessarily be fatal to the decision. It might be, for example, that the statute required a public authority to carry out a function within a certain time limit. If the public authority performed the function, but was a bit late, the court might hold that there had been substantial compliance so that the breach could be overlooked. Other legal areas to consider, see in particular. Question 12. Have I consulted properly? Question 13. Will I be acting with procedural fairness towards the persons who will be affected? Question 14. Could I be, or appear to be, biased? Question 12. Have I consulted properly? Consultation with the persons likely to be affected by the decision is very often part of the decision-making process. It helps to make the process a transparent and fair one and helps to ensure that the decision-maker is in possession of all the relevant information, so that the decision is a rational one as well. Consultation is generally desirable whether it is required by statute or not. Where consultation is undertaken, it has to be conducted properly if it is to satisfy the requirement for procedural fairness. 4 conditions have to be satisfied. Consultation must be undertaken when proposals are still at a formative stage. Sufficient explanation for each proposal must be given, so that those consulted can consider them intelligently and respond. Adequate time needs to be given for the consultation process. Consultees' responses must be conscientiously taken into account when the ultimate decision is taken. Failures of consultation, and indeed other lapses in due process, usually occur through inadvertence on the part of the decision-maker and the pressures of work. When such a lapse forms the basis of a challenge to the decision-maker may be tempted to say but it was an open and shut case. Consultation, or an oral hearing, or full disclosure of reasons, would have made no difference. The decision would inevitably have been the same. That may well be true, but the court is unlikely to be sympathetic to such a response. And for good reason. The principle is that only a fair procedure will enable the merits to be determined with confidence, and must therefore come first. Other legal areas to consider, see in particular. Question 11. Does the power have to be exercised in a particular way? For example, does legislation impose procedural conditions or requirements on its use? Question 13. Will I be acting with procedural fairness towards the persons who will be affected? Question 15. Have I taken necessary considerations into account, and is my decision reasonable? Question 13. Will I be acting with procedural fairness towards the persons who will be affected? As well as acting within the limits of its powers, the decision-maker will also need to come to a decision in a procedurally fair way. Without such procedural fairness, even if the decision-maker is not acting ultra vires, the decision may still be unlawful. The common law recognizes procedural fairness, or the existence of due process, as a key principle of just decision-making. Fairness is a concept drawn from the constitutional principle of the rule of law, which requires regularity, predictability and certainty in public authorities' dealings with the public. Where statute confers an administrative power, there is a presumption that it will be exercised fairly. What is fair will depend on the particular circumstances in which the decision is to be taken and may change with the passage of time. Such principles cannot be applied by rote, and what is fair depends on the context of the decision. It will be important to look at the terms of the statute and the parameters in which the discretion is to be exercised. It will often be necessary to allow a person or persons who may be adversely affected by the decision to have an opportunity to make representations and to have notice of the information on which the decision is to be based. It is a feature of a fair procedure or decision-making process that the person affected by it will know in advance how it will operate, and so how to prepare for it and participate in it. That is the importance of due process. Case law. Glasgow City Council and Dundee City Council v Scottish Information Commissioner, 2009. In a case involving appeals by two city councils against decisions of the Scottish Information Commissioner, one of the grounds of appeal was that the Commissioner's decisions were unlawful as there had been procedural unfairness. The Freedom of Information requests were submitted by a firm of solicitors on behalf of a client, who was unnamed but in fact a firm whose business is to find out and sell information about land. One of the City Council's arguments was that they could find out this information by paying for property inquiry certificates. Providing this information free of charge under F would, as well as involving them in a great deal of additional work and expense, prejudice their commercial interests. Without the knowledge of the two city councils, the Commissioner's staff conducted a survey of other relevant authorities to assess whether any of them had experienced damage to their commercial interests as a result of responding to similar requests. The evidence pointed to little, if any, damage to their commercial interests. Neither of the councils had been provided with any information about the Commissioner's investigations or their results, and they had not had the opportunity to respond to the Commissioner's findings. They had not been given the opportunity to explain why in their situation the result would be different. The court held that the procedure had been unfair and that the Commissioner should have given the council notice of any relevant material adverse to their position and invited their comments. Human rights, equal opportunities legislation and certain aspects of European law also require that a fair procedure is followed. At each stage of a process, a decision-maker should ensure that such issues have been properly considered and that rights or duties have been respected or followed, as appropriate. Case law. Huang v. the Secretary of State for the Home Department, 2007. In a case involving the removal of a migrant and whether that would infringe his right to respect for family life under Article 8 of the Convention, the court held that the task of the appeal body was to decide whether the challenged decision is unlawful because it infringes a convention right. It did not matter if the procedure in taking the decision was followed impeccably, but the appeal body must decide for itself whether the decision challenged was lawful, and if not, it must reverse it. The court may find that in the interests of fairness, additional conditions should be placed on the exercise of statutory or other executive powers. For example, the court may insist that, before a decision is made, any of the following is required: disclosure of the reasons the decision-maker intends to rely on, an opportunity for consultation or making representations, an oral hearing where appropriate, and after the decision, disclosure of material facts, or the reasons for the decision. Other legal areas to consider, see in particular. Question 4. Is there a policy on the exercise of this power? Question 5. Does anyone have a legitimate expectation as to how the power will be exercised? Question 8. Am I complying with human rights and European law? Question 9. How has equal opportunities legislation affected the power? Relevant considerations might also be the right to be heard and procedural conditions in legislation. See question 11. Have I consulted? See question 12. Do I need to give reasons? See question 18. Question 14. Could I be, or appear to be, biased? Question 14. Could I be, or appear to be, biased? One aspect of the rule of natural justice is that no one shall be the judge in his or her own case. If a decision-maker has a financial or other interest in the outcome of the case, he or she cannot be, or be seen to be, impartial. The rule helps to ensure that the decision-making process is not a sham because the decision-maker's mind was always closed to the opposing case. It deals not only with actual bias, but with the appearance of bias, hence the saying justice must not only be done, but be seen to be done. Nobody should be able to allege that the decision was a fix because the decision-maker was biased, whether or not there was any truth in that allegation. The rule must be observed strictly to maintain public confidence in the decision-making process. Impartiality is the opposite of bias. Its importance is enshrined in human rights. Article 6 of the Convention, Fair Determination of Civil Rights, requires that a tribunal must be, and have the appearance of being, impartial and independent. The rule against bias also applies to administrative decision-making, where there may be no tribunal as such, just as it does to the courts. It is prudent to have procedures available so as to avoid bias, or any appearance of bias. If, for example, the applicant for a grant is known personally to the decision-maker, or the decision-maker has dealt with the applicant before and decided against the applicant or expressed a view adverse to the applicant, it may be appropriate to refer the application to a different, or more senior, official. The principle can have practical implications for the process by which a decision is made. Very often, when statute requires that a public authority make a decision on an application, it, or the officials acting in its name, will require some sort of technical input, or it may be necessary to ask inspectors to carry out an investigation. In order to ensure as much impartiality as possible, it may be necessary to have structures in place so that there is a separation between the people providing the technical input or carrying out the investigation, and the officials taking the decision or submitting the matter to ministers, when a personal decision is required. This will reduce the risk of an unsuccessful applicant claiming that the decision-maker was not impartial due to being too involved in the case, or had predetermined the application. The independence of a decision-maker is different from, though closely linked to, impartiality. It refers to independence from external pressure or influence. It has much more direct relevance to judges, by reason for example of the way they were appointed, or the courts themselves than it has to administrative decision-makers who will often be civil servants appointed to carry out government policy or otherwise work towards securing the objectives of their employer. But even when a decision-maker is obliged to carry out a policy, he or she must keep an open mind, and any lack of independence should be curable by the availability of judicial review by a fully independent court. Actual bias is rare. Most cases are concerned with the appearance of bias. The test is whether, in all the circumstances, the fair-minded and informed observer, having considered the facts, would conclude that there is a real possibility of bias, that is, not a remote or insignificant risk. If there is, the decision will be set aside. Not only do you need to be sure that you are free of actual bias before making a decision, you also need to consider not acting as decision-maker if there is a real danger that your impartiality might be open to question. If parties know of a decision-maker's interest or previous participation, because, for example, the decision maker tells them, they can agree to waive the objection. If you are aware of any reason why you might be thought to be biased, it is wise to declare it at the outset. If the objection is waived, then it is very unlikely that there could be any objection taken later. In some rare circumstances, a decision maker who might otherwise be disqualified can still act, if the decision needs to be made, and cannot be made without that person. You should not decide to act in these circumstances without seeking advice on whether there is some way around the difficulty. Other legal areas to consider, see in particular. Relevant considerations might also be, Question 8. Am I complying with human rights and European law? Question 13. Will I be acting with procedural fairness towards persons who will be affected? Part 3. Decide. Question 15. Have I taken necessary considerations into account, and is my decision reasonable? We have seen in the discussion of Question 3 that when making decisions you must take into account all relevant considerations and not take into account irrelevant considerations. Crucially, when it actually comes to making the decision, you must not make a decision that is so unreasonable that no reasonable person acting properly could have taken it. These are often called the Wednesbury Principles after the name of the court case which first established them. The test of unreasonableness concerns the decision as well as the way in which it was reached. Even if the decision maker has taken into account the correct considerations, he or she may still come to a decision so wildly unreasonable or perverse that it can be judged to have been out with the decision maker's discretion to make it. If this happens, then the decision will be unlawful. The decision maker may even have considered all the relevant information and not considered information that was irrelevant. However, he or she may have attached a disproportionate weight to a particular factor or made some other mistake with regard to the logic of the decision, which has distorted the decision-making process. Case law, Standard Commercial Property Securities Limited v Glasgow City Council, 2006. A local authority wished to encourage the development of a key city centre site. It did this by identifying a developer, entering into an agreement to buy the land under a compulsory purchase order, and then transferring it to the developer. This was done in exchange for an undertaking from the developer that it would carry out the development and indemnify the authority from all future costs. Competing developers argued that the local authority had acted in a Wednesbury unreasonable way when it chose its preferred developer. They argued that an indemnity for their costs did not represent the best price or the best terms that could reasonably be obtained for the development of the site. The House of Lords found that the arrangement that had been entered into was reasonably necessary for planning purposes, given the difficulty of developing a site that was in multiple ownership. It could not therefore be said that the local authority reached a decision that no other reasonable local authority would have reached. The court has recognized that when different reasonable people are given the same set of facts, it is perfectly possible for them to come to different conclusions. This means a range of lawful decisions may be within the discretion of the decision maker. However, at the same time, the court has defined a category of decisions which lie outside that range of discretion. These have been described as a decision which is so outrageous in its defiance of logic or accepted moral standards that no sensible person who had applied his mind to the question could have arrived at it. Beyond the range of responses open to a reasonable decision maker. These definitions of unreasonableness, or irrationality, seem quite extreme, particularly the first. It might seem then that the court would hardly ever find a decision maker to have acted unreasonably. However, the court interprets this category of decisions quite widely and will adjust the threshold of unreasonableness according to the circumstances and context of the case. If a decision is challenged, the court will examine it to see whether it was made according to logical principles, and will often expressly state that it is not its intention to substitute its own decision for that of the decision maker. The court will not make its own decision in place of that of the decision maker because it bears in mind that the statute has given the discretion to make the decision to a particular decision maker, and it is not for the court to make that decision instead. The practical effect of this approach is that, where the court finds that the decision was unreasonable and that it has to be remade, the court will not put in place a more reasonable decision, but will simply cancel the unreasonable one, leaving none in its place. The decision maker will then be required to make a fresh decision, taking into account any guidance given by the court, and this time applying logical principles. In some cases the effect of the decision is such that it cannot be undone. If this is the case, then the court can declare it to be unlawful, which can lead to political embarrassment and possible damages being awarded. These would probably be payable from your budget. There are good practical, as well as legal reasons for the court adopting this hands-off approach. The decision-maker may be aware of policy implications or other aspects of public interest which are not obvious to the court, or the decision-maker may have access to technical information which is not available to the court and which must inform the decision. Other legal areas to consider, see in particular. Question 3. What factors should I consider when making the decision? Question 17. Does the decision need to be, and is it, proportionate? Question 16. Does the decision need to be, and is it, proportionate? Proportionality essentially means the decision should meet a legitimate policy goal and should not be going further than necessary to achieve that goal, i.e. it must be appropriate and necessary to achieve its aim. The court will adjust its view of what is or is not proportionate according to the importance of the rights involved. It will apply a greater intensity of review where, in particular, human rights are engaged. In other words, the court lowers the threshold for a decision to be found unlawful. This is particularly so because human rights bring their own specific rules of interpretation, which means the court will look at whether any action or decision which is alleged to infringe human rights was proportionate. In areas where European law applies too, a standard of proportionality will be applied by the court. The principle of proportionality may be used by the court where it is looking at an alleged breach of human rights or European law that has occurred because of the decision, or where it is dealing with the rights such as Article 8, right to private life, which necessarily involves a decision-maker considering if a decision to interfere is proportionate. Where the court is applying the principle of proportionality, it will generally look more closely at the correctness of the decision given the information available than it would by just applying the Wensbury unreasonableness test, see question 15. It is important to consider whether your decision is one that involves the area of human rights or is a decision made under European law. If so, the proportionality of your decision can be reviewed by the court if your decision is later challenged. Proportionality has also been argued as a ground of review for all decisions, outside the fields of human rights and European law. At present, however, proportionality is not currently an independent ground of judicial review at common law in its own right. Other legal areas to consider, see in particular. Question 8. Am I complying with human rights and European law? Question 15. Have I taken necessary considerations into account, and is my decision reasonable? Question 17. Are there decisions where the court is less likely to intervene? In principle, the court is entitled to review the vast majority of decisions taken by public authorities. In principle, because there are still a handful of types of decision with which the court is reluctant to concern itself, the award of honors is one example. Even these categories are increasingly restricted, and it can be imagined that if, say, the honors system were placed upon a statutory footing, with procedures, consultation and the like, then the court would no doubt be entitled to supervise at least procedural aspects. There remains a class of decision where the court accepts that, because of the subject matter of the decision, the decision-maker is better qualified than the court to make a judgment. So for example, the court is likely to defer to, or recognize a demarcation of functions with, the decision-maker in, ordering financial priorities, in deciding to spend public money in one way rather than another, assessing the needs of national security and public order, setting policy on maximum sentences for particular criminal offenses. The list could go on, and could be broadened to include any topic requiring specialist knowledge or experience, but what the above topics have in common is that they all concern policy, and require a political judgment to be made. In the demarcation of functions, that political judgment should be left to the decision-maker, who understands the policy and has experience of its operation to inform his decision. In this kind of area, the court may exercise restraint in reviewing the decision-maker, or recognize the demarcation of functions between the executive branch of government and the judiciary. The court is likely to allow a margin of discretion or discretionary area of judgment depending on the nature of the decision. Case law, R. On the application of Purdy v. Director of Public Prosecutions, 2009. This case involved a terminally ill applicant who wished to have her husband assist her to commit suicide but was concerned that if he did so, he might be prosecuted. As a consequence, she might have to end her life sooner than she would wish, while she herself was capable of doing so. She claimed that this was an interference with her human rights. The court recognized the considerable deference to be accorded to the views of the Director of Public Prosecutions in determining whether proceedings for an offense should be instituted, but nonetheless found that he should publicize a policy identifying the facts and circumstances which he would take into account in deciding whether or not to sanction a prosecution for assisting in a suicide. It is possible that your decision too will have an element of this kind of political judgment in it. You should identify that element and be prepared to protect it. The decision-maker will usually be allowed a discretionary area of judgment, but this cannot be taken for granted. And, where human rights are involved, the court is likely to be very careful to ensure that what the decision-maker is seeking to protect is genuinely an area of policy, and that the decision is proportionate. Part 4. Notify. Question 18. Have I taken necessary considerations into account, and is my decision reasonable? To what extent should I give reasons for the decision? When you have made your decision, in accordance with these principles, you will need to notify it to the person affected by it. In notifying that person, do you have to support your decision with your reasoning? And, if so, how comprehensive does your account of that reasoning have to be? You may also be under an obligation in certain circumstances to publish your decision more widely to ensure that anyone who will be affected by it has had adequate notice. Lord President Emsley's words in Wordy Property Company Limited v Secretary of State for Scotland 1984. In order to comply with the statutory duty imposed upon him, the Secretary of State must give proper and adequate reasons for his decision which deal with the substantial questions in issue in an intelligible way. The decision must, in short, leave the informed reader and the court in no real and substantial doubt as to what the reasons for it were and what were the material considerations which were taken into account in reaching it. Why should you give any reasons, unless statute or regulation require it? There may exist an established practice of giving reasons in this type of case, and failure to give reasons may breach a legitimate expectation. Your decision itself may appear to be inconsistent with previous policy, or with other decisions in similar cases, so that a decision unsupported by reasons may appear irrational, and it may be necessary to explain why there has been a departure from previous policy, or the court may assume the decision is unlawful. The subject matter of the decision may be of such importance, it may affect human rights, that fairness requires that a decision be supported by reasons. Case law, the Scottish Ministers v. the Mental Health Tribunal for Scotland 2009. In an appeal to the Court of Session against a decision of the Mental Health Tribunal, where the tribunal has a statutory duty to provide a statement of facts and reasons for its decision, the court held that the tribunal required to reach a clear and reasoned view on the application of the statutory test at issue. The court stressed that the tribunal must reach a decision based on the evidence, and provide clear reasons for making or failing to make findings that are central to the questions in issue. Where any evidence is rejected, the tribunal must give reasons for the rejection of that evidence. The requirement of a full statement of facts and reasons is not met by a basic assertion of the findings in law. Although it may still be true that there is no general rule requiring that reasons be given for administrative decisions, the circumstances where they are not required are becoming rare. Indeed, the general availability of judicial review as a remedy makes it inevitable that in most cases fairness now requires that reasons should be given. The law was developing in this direction even before the Human Rights Act incorporated the Convention, but that, in particular Article 6, right to a fair trial, has accelerated the process, because decisions involving human rights are likely to be scrutinized more intensely, and that means that they will have to be more fully reasoned. There is one other important factor which should now encourage the giving of detailed reasons with the decision. Rights for the individual who is the subject of a decision about their case to access information about that decision, including the reasons for it, may arise under the Data Protection Act 1998. In addition, Section 1 of the Freedom of Information, Scotland, Act 2002 provides that 1. A person who requests information from a Scottish public authority which holds it is entitled to be given it by the authority. So, assuming that, In making the decision maker had his or her reasons and recorded them. Any person will be entitled to request that information under the Freedom of Information, Scotland, Act, and, unless an exemption applies, that information will have to be disclosed. There are exemptions in respect of certain categories of information, and one or more of them may be relevant to your decision, but the presumption will be in favor of disclosure. The Act should therefore be a salutary incentive to careful reasoning and good record-keeping. This does not mean that every decision must be accompanied by copious reasoning. It will depend upon the subject matter and the importance of the interests at stake. Moreover, there will be some cases where the issue to be decided does not lend itself to logical analysis, but is more a matter of subjective judgment. Case law: The Scottish Ministers v. the Scottish Information Commissioner 2007. The Scottish Ministers appealed against two decisions by the Scottish Information Commissioner requiring them to release certain documents to two individuals who had made Freedom of Information requests. These related to the coming into force of an Act of the Scottish Parliament, and to the grant of a planning decision. Some information was released to them, but the Commissioner took the view that certain other information was exempt from disclosure under the Freedom of Information, Scotland, Act 2002. One of the Scottish Minister's grounds of appeal was that the Commissioner failed to give proper and adequate reasons for his decision in one of these cases. The need to record reasons when the decision is made with a view to their disclosure may be onerous, but it encourages careful decision-making. The record should show that the decision-maker addressed his or her mind to the relevant issues and followed the principles of good administration. There is no uniform standard for the quality or layout of recorded reasons, but they must at least be intelligible and address the substance of the issues. The following provides a useful outline. The record should be clear about what the applicant is applying for, and that you understand the application. It should set out material findings of fact. It should show that all relevant matters have been considered and that no irrelevant ones have been taken into account. It should cite and apply any relevant policy statements or guidance. It should note any representations or consultation responses as having been considered and taken into account. It should show by what process of reasoning issues were resolved, and how the various factors were weighted against each other. If all this, or as much as suits the case, is recorded, then it will provide a framework for your decision letter. The reasons given in the decision letter will of course correspond with those recorded, although there is some scope for elaborating or explaining your reasons in the decision letter, or subsequently, it is bad practice, and unlawful, to make your decision first and construct your reasons only when challenged. Other legal areas to consider, see in particular. Question 5. Does anyone have a legitimate expectation as to how the power will be exercised? Question 8. Am I complying with human rights and European law? Question 10. Am I handling data in accordance with data protection or freedom of information obligations? Question 13. Will I be acting with procedural fairness towards the persons who will be affected? Annex 1, the main convention rights. The main convention rights are: Article 2, right to life. Article 3, prohibition of torture. Article 4, prohibition of slavery and forced labor. Article 5, right to liberty and security. Article 6, right to a fair trial. Article 7, no punishment without law. Article 8, right to respect for private and family life. Article 9, freedom of thought, conscience and religion. Article 10, freedom of expression. Article 11, freedom of assembly and association. Article 12, right to marry. Article 14, prohibition of discrimination. Article 1 of the First Protocol, protection of property. Article 2 of the First Protocol, right to education. Article 3 of the First Protocol, right to free elections. Annex 2, EU law considerations. European law, including European Community, or EC, law, derives from the EC and EU treaties, and is incorporated into the law of the United Kingdom by the European Communities Act 1972. In some circumstances, provisions of the EC treaty, or of directives made under the treaty, confer rights on individuals. The aim of the EC treaty is to establish a free and open common market for all forms of economic activity. The EC treaty does this by establishing the four freedoms. These are the free movement of goods, persons, services and capital. Individuals may rely on those provisions of the EC Treaty and directives made under it in national courts even where the provisions have not been implemented in national legislation. Treaty provisions have to be sufficiently complete, clear and concise to be enforceable by a court. Provisions in directives must be unconditional and sufficiently precise. Directives which have direct effect can only be enforced against the state or emanations of the state, such as public bodies, so-called vertical direct effect. Directly effective treaty provisions also apply as between individuals. These rights are described as having direct effect. In addition, all European regulations are directly applicable and enforceable without the need for any national measures to implement them. Binding decisions adopted by the European Council of Ministers or the Commission bind those to whom they are addressed. If addressed to a member state of the EU, they may have direct effect, giving rise to rights which are enforceable in national courts, provided their terms are clear and precise. The 1972 Act requires questions as to the validity, meaning and effect of European provisions to be determined according to the principles of EU law, including proportionality. If there is a conflict between EU law and national law, directly enforceable EU rights and obligations take precedence. Domestic measures which are inconsistent, or which are considered to hamper the attainment of the objectives of the EC Treaty, may be found unlawful. In EU law cases, the Scottish courts have jurisdiction to grant interim remedies, for example, an interim interdict, which is an order to stop someone from doing something in the meantime, against the Scottish ministers, a UK department, or other public bodies. An order to disapply legislation, including primary legislation. The court can also seek an authoritative opinion on an issue of EU law from the European Court of Justice, ECJ, by way of a preliminary reference, sometimes called an Article 234 reference. After the ECJ has given its ruling, the matter is referred back to the domestic court to decide accordingly. The decisions of the ECJ on matters of European law form part of the national law of member states. Because the EU recognizes human rights, and the Convention, and fundamental rights under the treaties, as sources of general principles of law, these rights too can often be enforced in the UK courts as part of an action based upon EU law. Failure by the decision-maker to give proper effect to binding EU law conferring rights on individuals may give rise to a claim for damages. Community law will confer a right to compensation where three conditions are met. 1. The rule of law infringed must be intended to confer rights on individuals. 2. The breach must be sufficiently serious, manifest and grave disregard by the member state of the limits of its discretion. 3. There must be a direct causal link between the breach of the obligation resting on the member state and the damage sustained by the individual. Liability for such damages is one of the exceptions to the principle that, in general, damages are not awarded for a breach of public law. Damages of this type are often called Frankovich damages after a leading EC law case. A basic principle of EU law is that when the liability of a member state is considered, all its organs of government are treated as being a single entity. The Scottish Government is responsible for implementing EU obligations relating to devolved matters, and may be liable for any financial penalty for which it is responsible. The UK Government retains the legal power to implement EU law directly under Section 57(1) of the Scotland Act. Any Act of the Scottish Parliament, statutory instrument or Act of the Scottish Ministers incompatible with EU law is ultra vires and can be challenged under the Scotland Act. Annex 3, EU Law Considerations. A short guide to judicial review proceedings in Scotland. What decisions are reviewable? A decision or failure to take a decision affecting persons by someone empowered by public law and in respect of which there is no other available remedy. Will the court look at the merits? The court cannot substitute its own decision, but can quash a decision and send it back to be considered again, except where it is an ECHR case, when the court can re-examine the merits. See Huang v. the Secretary of State for the Home Department, 2007, and Nasseri, 2009. What will the court be looking at? Was the decision wrong in law? Did the person making the decision have power to do so? Did he or she exercise those powers correctly? Did he or she take all the relevant information into account? What's an irrational decision? one that no reasonable minister or public authority would have come to. Can you give me examples of procedural impropriety? A breach of duty to act fairly, failure to consult, being, or appearing to be biased, failing to take into account legitimate expectations would all be clear examples. What kind of remedy can the court award? It can quash decisions, award damages, make a declaration and make interim orders, including interim interdict. The court can of course also refuse the petition. What happens in a judicial review? Judicial reviews are made by way of a petition to the Court of Session in Edinburgh. All judicial review actions go to a judge for first orders to be granted. The first order allows the petitioner, the person challenging the decision, to serve the petition on the respondent, the decision-maker. It is at this stage that the petitioner can also seek interim orders, for example to prevent the demolition of a building until the court has an opportunity to consider what should happen to it at a full hearing of the case. If interim orders are sought, a caveat may be triggered. Caveats are a form of early warning system which respondents often put in place in the Court of Session in order to alert them in the event that a petitioner is seeking an award of interim orders against them. The respondent can then arrange to make representations to the judge before first orders are granted. Once first orders have been granted, the case will be assigned a date for a first hearing. If the matter is urgent, then this could be arranged at short notice. More often, though, a hearing may be fixed for some months ahead. The respondent can then arrange for an advocate to be appointed to represent their interests in the case. Where the respondent is the Scottish ministers, the advocate is drawn from a pre-approved list and is known as a standing junior. Standing juniors generally have either an interest or specialization in public law. You may be invited to attend a meeting or consultation with the advocate before the hearing, and are likely to be asked to provide information regarding the decision challenged for the purpose of instructing the advocate to appear, or seeking their advice. The first hearing can be either a short one, to decide on future procedure, or it can be a lengthier one, where detailed legal arguments are made on behalf of parties. It is also possible to have a second hearing, at which evidence can be led, either by affidavit, sworn statement, or in person. The judge may either give his or her opinion orally when he or she has finished hearing the case, or he or she may choose to think about it for a while, make avisandum, before issuing his or her decision. Opinions are published on the Scottish Court's website on the date of issue. Thank you for watching this legal presentation. If you have any legal queries, please contact info@stephenmorrison.co.uk.